And before we move to the election of the vice chair, Ms. Hakim, our board administrators advised me we have a deputation. Is Derek?
And directed to nominate Lisa Kostakis as its next vice chair, as there is no one more deserving than her to have this position. When Councillor Cheng here was being bullied recently for asking too many questions, and that meeting went completely off the rails with the decision made by the illegal chair at the time 2 hours into the meeting to arbitrarily switch over to using the Chapter 27 procedures used by Toronto City Council as a blatant attempt to prevent her from asking any more questions. When seemingly told to approve the illegal motion to do this, Lisa simply shook her head and said no. The Supreme Court of Canada in 2000 said in the City of Nanaimo versus Rascal Trucking, neither experience nor proficiency in municipal law and municipal planning, while desirable, is required to be elected a councillor. Given the relatively broad range of issues that a municipality must address, it is unlikely that most councillors will develop such special expertise even over an extended time. So on that, and especially after the humiliating way Miguel was treated last week at City Council, I object to anyone from the Corporation of the City of Toronto holding this position, as it is not in the public's interest to have anyone from this Roman municipal civil law jurisdiction that continually defrauds the public with their corporate bylaws and thumbs their nose at the common law. The common law, by the way, which the SIU director mentions at the very bottom in one of the administrative inquiry items on this agenda. In the immortal words of Billy Madison's principle, we are all now dumber for having listened to anything Councillor Nunziata had to say here. I award her no points, and may God have mercy on her soul. Also, the Supreme Court of Canada said in the Committee for the Commonwealth of Canada versus Canada in 1991, expression in a municipal council chamber would be protected because expression is not incompatible with the function of the council chamber. It could be argued, for example, that the parliamentary library could function quite well despite the presence of demonstrators holding placards. It went on to say that it is likely that wearing a t-shirt, right? Miguel was kicked out of City Council for wearing a t-shirt by the lady that you so glowingly said thank you for all her, whatever she contributed here, by the way. It is likely that wearing a t-shirt bearing a political message would be a form of expression consistent with the intended purpose of such a place. In R versus Keegstra, 1990, Supreme Court of Canada said, as this court has repeatedly affirmed, the content of a statement cannot deprive it of the protection accorded by Section 2B, no matter how offensive it may be. The content of Mr. Keegstra's statements was offensive and demeaning in the extreme. Nevertheless, on the principles affirmed by this court, that alone would appear not to deprive them of the protection guaranteed by the Charter. This is from Bracken versus Regional Municipality of Niagara Corporation, 2015, where the Superior Court of Justice said, the region also concedes that the council chambers are public property, which the applicant is entitled to use in exercise of his right to freedom of expression, unless that right seriously interferes, which Miguel did not do last week, with the use of the public property by the city or other individuals. This is Bracken versus Niagara Parks Police, 2018. The application judge erred in finding that Section 29A does not infringe Section 2B of the Charter. Mr. Bracken stood in Grandview Plaza in Niagara Parks holding a sign reading, Trump is right, fuck China, fuck Mexico. To take a familiar example from U.S. First Amendment case law, the meaning conveyed by shouting fuck the draft does not translate without significant loss of meaning to the quiet declaration that I am implacably opposed to the draft. That's from Cohen versus California in 1971. This is the most important point, so this doesn't happen to anyone else, what happened to Miguel down at City Hall again. Abusive or insulting language has expressive content. And I wouldn't normally come here and say the F word, I don't feel the need to, but Miguel literally does not have that word printed on his shirt. There's a red maple leaf replacing the U. Nonetheless, he was still kicked out on the basis by, again, Councillor Nunziata, because in council chambers, supposedly, there is no advertising allowed on someone wearing a t-shirt, which is the most cockamamie thing I've ever heard, and good riddance to her.